Good morning, Mr. Wood. You may proceed.
May it please the court, Chauncey Wood for the appellant, Rashidi Smith. The first question this court has to address is whether it should expand the scope of the common law interested adult rule to include 17-year-old minors in light of the act expanding juvenile jurisdiction. Assuming the court answers that question, yes. The next question is whether Mr. Smith is entitled to the protection of the expanded rule where, one, he was interrogated before the passage of the act, but two, his attorney asserted prior to trial that he was entitled to the benefit of the expanded rule because he was a minor, and three, the case was still on direct appeal at the time of the passage of the act and the expansion of the rule.
Isn't this incredibly unfair to the Commonwealth? An interview that took place 6 years before this new rule, common law rule that you're asking us to adopt, should somehow apply? How is this fair to the underlying litigation?
I think it's actually incredibly unfair to Mr. Smith and to juveniles who are 17-year-old juveniles to be custodially interrogated without being asked.
But that was approved. That was the norm. There was nothing wrong with it at the time.
Well,
and one could argue whether, well, maybe we ought to change that. But 7 years before?
Right. I mean, when you say there's nothing wrong with that, I think
what about the victims in this case?
I think, let me answer as many of these questions as I can. Science would indicate that there was a lot wrong with that. I think that it's the universal scientific opinion now that juveniles do not have a frontal lobe that is sufficiently developed to be able to make an adequate, knowing, intelligent, and voluntary waiver of Miranda rights without consulting with an adult. So as a matter of neuroscience, and this is a universal position, by the way, there was very much wrong with that. It's true, as Your Honor says, that that was not the way things were done, but with the benefit of hindsight, we now know that there was a lot wrong, even though we didn't know it. So I think that's an important point.
So why shouldn't we just make it retroactive for everybody if it was so very wrong and unjust?
That's not my case, and I am not going to venture an answer to that difficult question. I think that it is certainly troubling.
Help me understand how we get to where you want the court to go, given the cases that tie the interested adult rule to the definition of juvenile. I understand what you're saying. We have new science now, but how do we get there?
Yeah.
If we're stuck with calibrating the need for the rule with the definition of juvenile.
Right. I think the case law dictates the result that I'm seeking. The first question that I pose, whether the court should expand the rule, this court's precedent dictates that the act expanded the scope of the interested adult rule to include 17-year-old minors, and I cite the court to Commonwealth v. Carey. In Commonwealth v. Carey, this court ruled that the scope of the interested adult rule is dictated by the legislature's definition of a juvenile.
Right, but we know that the definition of juvenile isn't retroactive to your client.
Well, I'm not sure. Okay, the second part of the answer to your question is, so the first part, this is analytically the way I approach this, and I suggest the court should approach it. The first question is, should the court expand the interested adult rule to include 17-year-old minors?
I'm with you on that. I'm just trying to figure out what's the legal approach to getting from there to here, where you want to be. Just help me with that.
Yes. So if we agree that Carey, and I think we do, if we agree that Carey essentially dictates that the scope of the rule is tied to the definition of juvenile, and at least going forward, therefore, the interested adult rule applies to juveniles, which includes 17-year-old children. Right. Your question is, okay, but what about Mr. Smith, who is where this happened before the passage of the act? The answer to that, I suggest, also lies in this court's precedent. And that precedent is cited in my brief, Commonwealth v. Adjutant and Commonwealth v. Figueroa. The precedent dictates that where a defendant, and this is a common law rule, and this court's general approach is that where a defendant anticipates a change in a common law rule, in this case the interested adult rule, prior to, at his trial, notifies the court that he's seeking that change, and then the change occurs before his case is final, he is traditionally entitled to the benefit of that rule. I cite Commonwealth v. Adjutant and Commonwealth v. Figueroa for that. Here, Mr. Smith's lawyer, prior to trial, anticipated the change that occurred in the common law interested adult rule when he filed a motion to suppress, saying that his client was entitled to the benefit of the interested adult rule because he was 17 and a minor. So the argument is that this is simply a change in the common law, an expansion of the common law rule, and it was anticipated by counsel. He preserved the issue at trial, and the case is still on direct appeal.
But it never would have happened unless the legislature amended the statute, which it did 6 years later. So it's not like anticipated a change in the common law, really. Did you anticipate a change in the statute many years down the road?
Well, I
would have lost in 2007, 2008, 2009, 2010, 2011.
You would have. I'm simply citing to the court to the law, and the law is, as I think, fairly stated. And I think it's important to recognize that Mr. Smith is probably unique. I'm not aware of any other case. So really, this decision applies to one defendant, and I think will have precedential value for one defendant. I think there's not...
You really think so? That there would be no other minor charged with murder?
Whose lawyers anticipated the change in the law 6 years before the change in the law. So I submit that under my reading, and I think this is just, I'm not trying to be crafty here, I'm simply reciting back the precedent from this court on the application of the common law rules of evidence in those rare instances where the defendant anticipates a change and puts everybody on notice, and then the rule, miraculously perhaps, changes. So
is this a change like adjutant, though? I mean, I understand what adjutant refers to, but this is not a change in the common law. You're trying to get a change in the common law.
Well, I think that, so if this court, in adjutant, this court, in a decision by Justice Cordy, changed the law and changed the common law rule as requested by Ms. Adjutant. And in fact, the court gave her the benefit of that change in the law. Today, I'm coming before you, and I think the preliminary question is, once again, the exact same thing. Should you change the common law rule, the scope of the interested adult rule? And I'm saying, yes, you should change it. And I'm saying further that I'm entitled to the benefit of that change because my client's attorney, just as Ms. Adjutant's attorney, anticipated the change in the law, made the request prior to trial, and the change would be occurring at precisely the same moment in my client, Mr. Smith's case, as it did in Ms. Adjutant's case.
And
so I think
go ahead.
No, I'm done. I think that's precisely analogous to the Adjutant case.
So if one accepts your argument, then it goes back and there's a hearing on, what's the hearing?
What happens next?
Yes.
Right.
What happens
So
next?
I think that what happens next is that the case is remanded. I should say that the Committee for Public Counsel Services, ACLU, amicus brief, I think there's other parties involved, advocates a broader rule.
I appreciate that.
Right.
But let's just say this is the rule. In
Right.
other words, the one that you have advocated.
Right. Okay. The more limited position that I've advocated is that we simply apply the interested adult rule as it currently exists to 17-year-olds the same way it applies to 14 to 16-year-olds. So and the question is, did he have a genuine opportunity? And if he didn't have a genuine opportunity to consult with an interested adult, did he possess enough intelligence, experience, knowledge, or sophistication to indicate that his waiver was truly knowing, intelligent, and voluntary? So we need to, because the trial judge did not, I'm not sure if it was the trial judge, Judge Locke, I can't remember if he was the trial judge, because he did not apply that inquiry in the suppression hearing, we need to go back, I guess to Judge Locke, and ask that he conduct that inquiry. So it's a limited inquiry. I think probably that doesn't even require, I think I'm not asking, I should know the answer to this, for a vacation of the conviction at this point. I'm asking for that limited remand for that evidentiary hearing. And then if we find at that point that if he finds that the confession should have been suppressed, then we've got the subsequent question. I think it's also important to say, I wanted to actually go back to Justice Cordy's initial point that I'm not saying that the Commonwealth did anything wrong. I'm not saying that, certainly not saying that the police did anything wrong. But the issue is not whether the police did anything wrong. The question is whether the confession, the Miranda waiver was knowing, intelligent, and voluntary. And I think that science gives us strong reason to doubt, given that we have a 17-year-old's frontal lobe that is not fully developed, that there is a serious question about that. So that's what we're really talking about here. And then also, the Watts case, to the extent the court has any, I think the Commonwealth's going to get up and say, Watts decided, this court decided this in Watts. And they said, this court said quite specifically that this will be, if we apply this act retroactively, then people will be able to raise this interested adult rule challenge. I think that it's apples and oranges. It's clear that, I'm seeing some nods, but just in case, that the primary driving force in Watts was the practical consequences of shifting 8,000 or more cases from from the Superior Court to the Juvenile Court. As I think I've made clear, here we don't have those practical consequences at all. We have one case, and I indeed think that, at least the way I conceive it, it's very unlikely that there will be any more cases that, to the extent we all agree that prospectively this applies to 17-year-olds, everybody's on notice going forward, but retrospectively, and I don't actually think it's a retroactive application, because that's retroactive application applies only to collateral cases. This is on direct appeal, so actually technically I don't think we're talking about a retroactive application. But retrospectively, I think that this is the only case, and one of a vanishingly small number of cases.
So what happens between the time this statute was enacted and today? All right, so we haven't changed the interested adult rule. Surely there have been some interviews between the time of statute enactment today. What about those? What's the test there?
Not my case. I haven't thought about it deeply, but I think that the way I've conceived it, defense counsel has to, the crucial point from my case is that one crucial point is that defense counsel put the court on notice by raising the issue. Your hypothesis, I think it's unlikely that this narrow window of, I think, what was it, September of last year? It's been about a year. Okay, so I'm trying to quickly conceptualize it. Defendants who raised, first of all, if you didn't raise the issue after the passage of the act and you've already pled guilty or been convicted, then I think you're in a difficult situation, clearly unlike my client.
But it's not, it's not retroactive in the traditional sort of Teague versus Lane frame.
Right. But the first question is whether you raise the issue. And if you haven't yet been tried, then that's not an issue, because you can still raise the issue now, I would say, as long as you raise the issue. And then for those people who haven't raised the issue, I think it's a substantial risk of miscarriage of justice analysis, and I'm not sure. I think it would be case-specific, but it wouldn't be my case.
But there still is, the fact of the matter is, the police had no reason to say we should give you an opportunity to meet with an interested adult, because that was not the law at the time.
Right. That's certainly true, and I think legally that's insignificant. I don't mean to, and I'll repeat what I said. I'm not blaming the police for not doing their job properly. I think that the police did their job properly. I think it's an interesting point, though. Well, I want to answer your concern. It seems to me that legally that's irrelevant. The concern here is that the defendant's waiver, we have a proper inquiry into whether this 17-year-old child's Miranda waiver in a murder custodial interrogation was truly knowing, intelligent, and voluntary. That's really important. And the way we decide that if he's 16 or younger is we have this analysis. The officers fairly saw he was 17 and said, okay, we don't need to go into that analysis. But the point is still there, that there's a serious concern whether his Miranda waiver, given his immature frontal lobe, was invalid.
You say that, but I don't know, do we have any as part of this record? Is there any research that speaks of Miranda as part of this record?
Well, when you say this record, there's a lot of, all the research is gathered in the appendix of the
amicus.
Of the amicus brief. I cite it extensively in my reply brief. So there's lots of, the record contains lots of research about...
But with regard to the judge...
Right. The issue was not, that's right, there was nothing...
They objected to it, but they didn't basically go to the judge and say, Your Honor, the research demonstrates that this person should be treated as a juvenile because his brain is still, the frontal lobe is not developed and all that. So this judge did not have anything before him that says, you're right, I should view it in terms of the research and I should change the common law. You're basically arguing here, the statute changed, it makes sense to change the date to conform to what is now a juvenile, and that's what we should do.
I see my time is up, but I want to just answer that briefly. For the judge, given that the act hadn't yet been passed, the matter was very simple, and I submit as a result it would have been sort of a, well, I don't know, pointless effort for defense counsel to try to get a lot of scientific research into the record. As you noted quickly there, the trial judge had precedent in front of him. It was a very simple matter. I cite Commonwealth v. Carey. Your client was 17 years old. Ball game. You lose. And so I don't have the power to change the precedent. I can't overrule the SJC and Commonwealth v. Carey. Your client was over 16. That's the end of it. So I think it's impractical and a waste of everybody's time in a busy Superior Court for the defense counsel to try and show him science to say that this decision is wrong because the trial judge doesn't have power to change the decision, notwithstanding the science. So I think that's the practical answer to why there wasn't evidence before the trial judge. But at the end of the day, I don't think it matters because I think that doesn't undermine my argument in any way because the science is the science. There's no dispute about the science. It's now part of the record before this court, and the argument is really this court, in light of the act and the science, should change the rule. This is the venue to come to with the science to say, not only is the act changed the rule, or giving you a reason to change the rule, but the science fully supports the change in the rule.
And this is just a prophylactic rule. That's all it is, really.
Yes, it's an important prophylactic rule, but yes, it's a prophylactic rule. Thank you.
Thank you.
Good morning. If it pleases the court, Gail McKenna, Assistant District Attorney for the Commonwealth here. What's been argued today in the defendant's brief is that the changes in the juvenile law automatically made the interested adult rule expanded to age 17. I think that this court's decisions in the Watt case make that clear that it is not, that act is not retroactive. It would not go back 6 years in time to an interrogation that completely comported with all of this court's rulings and prophylactic law.
So, excuse me, are you saying that, what part of the argument are you addressing? The first part, that the rule should not be prospectively inclusive of 17-year-olds, or that it shouldn't apply to this defendant?
Well, I'm starting with what the defendant argued in his brief, which is that he's entitled to it as a matter of law, that the amendments to the juvenile law apply to him because they changed the common law, and that they apply to him retrospectively to 2007 when this interview took place.
What's the Commonwealth's position on whether or not the act, in fact, provides a definition of juvenile?
Well, it does not.
All right. So you're saying that the interested adult rule should not be one that requires 17-year-olds to receive the benefit of it?
It should not. My argument is that the humane practice rule is sufficient, that it takes into account age, maturity, and in fact, my argument was confirmed with the science that was supplied to this court, which specifically says, and I point to the record appendix supplied by amicus in this case, that 16 and 17-year-olds understand Miranda as well as adults. So therefore, they don't need this extra protection that's been supplied by the court. That supports that argument. I mean, we have very, very strong voluntariness laws here. We have to prove the Commonwealth beyond a reasonable doubt that the statement is voluntary, which is different than other jurisdictions where it only has to be proved to a preponderance of the evidence. Youth and maturity are already a piece of that. There's no requirement, even under
Your argument would get rid of the prophylactic rule altogether, right?
Well, you know, I'm saying under the science that's been presented here, it at least should be kicked back to age 15. And I'm not suggesting that someone under 14, which is essentially a pre-adolescent and different than an adolescent, I'm not making any suggestions about that. It's not before the court. But I'm saying that our voluntariness rule, which is stronger than what's out there otherwise, is better than what other people have. Also looking at some of the science that's presented by the amicus when it comes to the specific science having to do with Miranda and interrogations, what they say is the way that we fix problems in juvenile interrogations is we record them. Done. We don't permit officers to lie or to be manipulative, in other words, to be coercive. Done. We already do
What's the
that.
cost to the Commonwealth to do this? I mean, they're already doing it for 14 to 17-year-olds. What would be the harm?
Well, it's not the fact of what would be the harm. The fact is what should be the law.
More protection than less. Shouldn't that be the law?
No, it should not, Your Honor, respectfully. I mean, police have an obligation to interview witnesses, to interview juveniles. We have an obligation to attempt to solve crimes. And in the case of juvenile, the court specifically pointed out that one of the things that they were doing was balancing those rights, the rights of all people, with the individual rights of a juvenile, and trying to protect, in the purpose of the rule being to make sure that statements are voluntary. So if we don't need extra protections to make sure statements are voluntary, why are we putting them there? We're already doing the things here in Massachusetts, DGM Batista, our special protections that make sure that the safe harbor rule is another one. The other thing that the science says is when an interview goes over 6 hours, that's when an interview starts to become, to a juvenile, coercive, and juveniles start to falsely confess. The other piece that we have here is that we don't have a false confession. We don't have any of the indicia here, any of the problems here that all of the alleged, uncontroverted science, and I would say a lot of it is controverted. There are other studies out there, and it would be, a lot of this stuff should be subjected to Daubert-Lanigan hearings before the court simply accepts a data dump. But
Wait. We have Miller, we have all of those cases, and we have Diachenko. We have a substantial body of scientific research that would support this.
we have that research on Eighth Amendment punishment issues, which have to do with
I
rehabilitation.
understand that.
Not on Miranda.
But all of those issues tell us something about, the way the court has treated those issues, tell us something about the development of juveniles. I mean, there is a problem with 17-year-olds. Our legislature has said that. So I don't understand why you think we need some more scientific evidence, why we would have to have some kind of Daubert analysis before we say this is the right thing to do for
There's no
juveniles who are
correlation.
17 years old.
There's no correlation between the so-called scientific evidence that's been presented in this case and Miranda, except for the piece that I've pointed to you.
So we
Which is that
couldn't look
piece?
at, we couldn't
I'm
look
sorry.
at what we already know about juveniles if we wanted to extend this rule?
No, Your Honor, you couldn't.
Why
I think it
not?
would be incumbent on you to
Why-
take
why-
evidence.
Why couldn't we?
Because it's not established, it's not self-evident.
So what?
I
what
would
be-
suggest that this-
What would we have to know?
I think that each and every one of the so-called experts should be subjected to cross-examination like we do with any changing science.
Okay, my question is, if a judge were to have a hearing, what would the judge be looking for from an expert?
The judge would be looking for some correlation having to do specifically with voluntariness and Miranda, having to do with the age of this particular defendant, because we measure voluntariness based on a particular person. And if the court found that there was something that said all defendants or the vast majority of defendants, maybe we come up with a prophylactic rule at that point, but we're far from that point. We don't have evidence except that what's been presented here, and Judge Cordy, I need to get that cite for you.
That would be great. You can do it in a 16L if you want.
It's the Feld studies, it's page 195 and 325.
195 through
And 325, there's two studies by Dr. Feld, I believe he's a lawyer. 16 and 17-year-olds understand Miranda at the same cognitive level as adults. That's our science here. And he makes the recommendations that I talked about here, the Commonwealth is already doing. That's another problem with dealing with all of these studies. They're talking about the whole country. They're not talking about Massachusetts, interrogations that take place in Massachusetts.
Are 17-year-olds are different than those in Kansas?
No, but the things that we're already doing are different than the 17-year-olds in Kansas.
The interrogation techniques
Are
you're
different.
referring to are different.
Very different. You know, and in fact, this court already put into effect a safe harbor rule. We're not interrogating people for 7 hours. You know, we're not doing that. We're not taping interviews. We're taping them. These are the specific things that have been said in these studies that support that when we're talking to juveniles that we're getting voluntary confessions.
When you said that these two studies refer to juveniles who are 16 and 17 as having the same cognitive capacity as an adult for purposes of understanding Miranda, that's not exactly the same thing that these other studies have been talking about that gave rise to the Diachenko case in Miller. Those studies talk about an undeveloped frontal lobe that makes juveniles susceptible to peer pressure, to impetuousness and in bad judgment, other kinds of mental processes. Do these two studies address those concepts as well?
Well, you know what, I think we have to take a hard look at those studies too, because part of what's wrong with those studies is that they've truly demonized children. They say that all children are reckless, impulsive, out of control. There are lots of other studies out there that say that the child's brain is not broken, that children have the ability to make good decisions, that they're learning, and that they make good judgments. Some of the other studies say we're really only talking about a small number of children here, but instead we have the Supreme Court rules, no Daubert-Lanigan, no testing of all these studies, simple adoption of them without the type of vetting that we have in our adversary system, where we would have really looked at these and said, hey, look, this isn't all children. This is only particular children. But, you know, I'm not arguing that against the precedent of the Supreme Court, but that was part of the decision-making there, that they adopted this so-called science, and all of us have seen science change. In the 80s, there was an ice age coming. That's gone. I remember when cranberries caused cancer, and then it was bacon, and we had the list over and over again, and that was all
You're
science.
very old. You're very old to
I'm
remember all that.
tremendously old, and I'm glad you're all nodding along with me. But
And enjoying cranberries again.
to say,
Do we give any weight to the fact that there's that statute, and if Chief Justice Ireland were here, he would be able to cite it, which says, with regard to juveniles, the purpose of it is to rehabilitate, that we treat them as children. There's that quite lovely paragraph in the statute which speaks of the difference between how we treat juveniles and adults. And now 17-year-olds are entitled to the benefit of that lovely provision which says our purpose with regard to juvenile justice is different than with regard to adult justice. And is this not part of that overall purpose?
well, here's the problem with that. Because even if you accept that somehow the changes in the statute change the interested adult rule, they don't change them for this defendant because he's not a juvenile under the statute. He's a person. He doesn't fall within, he's not a minor, he's not a juvenile. He's not entitled to treatment in the juvenile court as a delinquent.
Between now or at the time of the examination?
Both, and now as well. He comes under the part of the statute where he is a 15 to 17-year-old, 18th birthday, who is a person charged with murder at the Superior Court.
But the question is, other 17-year-olds will now get the benefit of this rule, so we're not talking about whether 17-year-olds in the future will get the benefit of the rule, perhaps. But why shouldn't this juvenile be treated as every other juvenile who will be charged in the future? Presumably, this rule could apply in the future, and I guess what we're trying to figure out is if we say that it will apply in the future, should it apply to this juvenile? Why is he different if it applies to others?
Because, number one, when his interrogation took place 6 years ago, every single rule of this court was followed, including the common law
I'm
rule.
just talking about the policy underneath, the same kind of consideration that Chief Justice Gantz just asked you about. If there's a reason to have the rule for 17-year-olds going forward, why wouldn't that apply to this juvenile?
Because it's unfair. And we started with that question right out of the gate. It's unfair. It's unfair to every single person that worked in this case under the rules established by this court. And remember, this is a common law rule. This is not a constitutional rule. This is a rule that says, is a matter to try and make sure that a juvenile's statement to the police, his interrogation, is voluntary. This is something extra that we Massachusetts are going to do. Very few states do this. We do. So to say, well, wait a minute, you followed all of the rules, but now we're going to pull the rug out from under you, is fundamentally unfair.
Let me ask you with respect to Adjutant and Figueroa and to the applicability of a change in the common law. There are different kinds of rules.
Yes.
Adjutant, I remember, it had to do with the admissibility of evidence at trial. Figueroa, unfortunately, I don't remember. This is a case where the suggestion is that the common law be adapted to change the conduct or the manner in which non-court personnel operate in the course of their business, namely the police and how they're going to conduct investigations.
Well, that's right. And normally when we have a prophylactic rule like a motion to suppress, the point of the suppression is to remove evidence where there was some illegality. There's no illegality here. But I think I still have to address, was it not voluntary? And certainly it was. The other thing I need to bring up, too, is this wasn't preserved at the Superior Court. This issue wasn't. What came up was that just like in his brief on appeal here, the defendant said that as a matter of law, well, slightly different, as a matter of law, under existing law, Commonwealth versus Guyton, I'm entitled to this as a 17-year-old, completely contrary to all law. He didn't say, hey, I want a change in the law. I'm predicting that there's going to be a change in the law. He was trying to hoodwink the judge. And he said, this is the law and I'm entitled to it, so this is how I want you to rule on voluntariness. So that's what happened at the Superior Court. So thank you all for your kind attention. I'd respectfully request that you affirm the conviction. Thank you all.